Hello and welcome to the Herrington Carmichael Employment Law Update for February 2016. I'm Alistair MacArthur, I'm the head of the employment team here at Herrington Carmichael. I've got 4 key employment law developments to talk to you about this month. Firstly, the much publicised national living wage. This comes in with effect from the start of April. Now, the rates are going to be £7.20 per hour for those employees aged over 25, and this is due to rise to £9 per hour with effect from 2020. It's very much a remodelling of the national minimum wage, as you would already know. It is important though for employers who have low paid workers to be getting your wage rates right now. You don't want to get stung by fines, so get them right, get them effective from the 1st of April. Make sure you're paying people the right amounts. Secondly, we're moving into case law now. So the first case to look at this month is the case of Barbulescu versus Romania. Much publicised, you'll have seen it on many websites. It relates to employers monitoring employees' personal messages. With this case, it went all the way to the European Court of Human Rights, and Mr. Barbulescu argued that his right to privacy was being infringed. The European Court of Human Rights said no, that the employer was perfectly entitled to go and look at these messages. What does this mean for you? What it means is you should still have clear policies and processes permitting you to go and look at personal messages which may be sent through your company servers. Make sure you've got your social media policies, make sure you've got your IT policies up to date. If you don't have those though, it's not all and done for. You can still try and rely on this case to go and look, but it's still better to get those policies right first. Third thing to talk about is age discrimination comparators. This month we saw the case of Donker and the Royal Bank of Scotland, which went all the way to the Employment Appeals Tribunal. Mr. Donker was arguing that because he was aged over 50, the Royal Bank of Scotland had denied him early retirement benefits that they would have given to a younger, under 50 employee. What the Employment Appeals Tribunal said is that this was an age-related benefit, and if the Royal Bank of Scotland were going to deny Mr. Donker this, they had to be able to justify it. So if you're offering age-related benefits, make sure you've got clear justification as to why you are paying particular groups of employees particular amounts, particularly if that's related to age. Lastly, we have the case of the Queen on the application of Fleet Maritime Services versus the Pensions Regulator. This case related to which employees are entitled to benefit from pensions auto-enrolment, and particularly those employees who work outside of the UK or regularly outside of the UK. And the case related to an employee who was a seafarer who went about his business going to various ports. And the case basically says that if you're regularly working in the UK, you have to benefit from pensions auto-enrolment. So if you have employees who work across a number of jurisdictions, who work across a number of different locations, outside of the UK and inside the UK, you need to look very closely at this as to whether you need to be complying with your pensions auto-enrolment obligations or not. That's it for this month. Thank you for listening. As always, if we can be of any assistance to you, please don't hesitate to contact us, and I look forward to speaking to you again next month. Take care. Thank you.